Good afternoon and welcome. I am Ilda Obasonya and I'll be your host for the next 60 minutes. This session is brought to you by Optal in cooperation with the NBA SBL ahead of the 20th NBA SBL International. We are joined today with two distinguished attorneys who are, over the next 40 minutes, we will explore how regulatory reform is reshaping contract work and how artificial intelligence is beginning to change the practice of law and what all that means for Nigerian lawyers and legal professionals today. Before we begin, a word on our co-host. The Nigerian Business Law is the NBA SBL, is Nigeria's foremost association of business law practitioners, bringing together lawyers advising on transactions, regulatory matters, and commercial work across every major sector of the economy. The annual conference is one of the most significant gatherings in today's conversation. Allow me to introduce our guests for today. Our first guest for today is Rotimi Ogunyemi. He's a technology attorney and partner at BOC Legal, a member of the Johnson and Wilner Alliance, where he leads the firm's emerging and advanced technology practice. His advisory work encompasses legal, regulatory, and strategic issues at the intersection of law, innovation, and digital transformation, with a focus on artificial intelligence, data governance, cybersecurity, and platform regulation. Currently, he is an executive committee member of the NBA SBL and a former chair of its technology committee, where he helped shape national conversations around legal innovation and digital policy. As a speaker and policy contributor, Rotimi regularly facilitates high-level trainings on technology law, corporate governance, artificial intelligence policy, and legal innovation. He's active in global technology circles, including the Global Blockchain Business Council and the IBA's Technology and Academic and Professional Development Committees. His advisory expertise includes guiding stakeholders on leveraging emerging technologies such as artificial intelligence, digital platforms, and smart infrastructure in highly regulated environments. With a passion for knowledge sharing and technological advancement, Rotimi continues to work to shape the field of technology law, policy, strategy, and governance in Nigeria and beyond. Together with everyone here, let's welcome Mr. Rotimi Ogunyemi. Our next speaker is Diana Uzo. Diana Uzo is a lawyer, technology policy advisor, and certified global privacy professional, currently serving as a privacy advisor at MTN. She works at the intersection of law, digital rights, and emerging technologies. Prior to this, she advised organizations ranging from big tech companies to African regulators and startups on building privacy-first products and effective compliance programs. She's also the founder of Learn with Diana, a platform where she teaches questions, existing approaches, and continues learning in the presence of an audience. She curates Africa Tech Policy Gist, a newsletter that breaks down tech policy trends across the continent for a wider audience. Together with everyone again, let's welcome Diana Uzo. We're happy to have you here today with us.
Thank you so much. I'm happy to be here, Hilda.
Thank you. So a few logistics before we begin. Today's session will run for 60 minutes. We have a 40-minute moderated discussion, followed by a short demonstration of the Optal AI platform, and then we'll close with some remarks about the June conference. The session is being recorded, and the recording will be shared with all registrants after the event. If you have questions as we go, kindly use the Q&A box. We'll address audience questions as time permits. So, having said all of that, welcome again to today's webinar. So, Mr. Rotimi, I have an interesting question for you today, and I'm sure our viewers, the audience, are also here eager to learn. So in the last decade, in the last 10 years, so we're saying from 2015 to 2025, we've seen a lot of regulatory reforms. Regulatory reforms, the CAC, the introduction of the CAMA 2020, We've seen the NDPA, the NDPR, we've seen the FCCPA Act of 2018, we've seen the ISA of 2025, and even the tax landscape is not left out. From your experience advising clients, which of these reforms would you say has had the most direct impact on how deals are structured and on how contracts are being drafted today?
Thank you, Hilda. Good afternoon, everyone, and good morning for the folks at Portal. It's a pleasure to be in this conversation and, of course, doing it alongside Diana. Your question is an important one, and truly you have situated your question right. In the last couple of years, from 2015 till date, there's been a slew of legislation. And the practical way I would like to answer this question or frame it is to say, first of all, that passing any kind of reform legislation on paper is always only the starting point. And the real impact begins when that reform hits live transactions. Like you've mentioned, we've seen the CAMA 2020, we've seen the Business Facilitation Act, we've seen even the Electricity Act, and of course, the recent Tax Reform Acts. Not forgetting the Investment and Securities Act. Now, one major common thread, before I answer your question, one major thread amongst all of them is that since the enactment of this slew of legislation, Nigerian lawyers, particularly business lawyers, have had to revisit their historical clause libraries. That's their contract clauses. Like we all know, we thrive on precedents. Now, what that means is what may have worked perfectly well in 2014, 2015, today in 2026 will most likely be a disaster by way of our contracts. Now, in terms of answering your question, to me, and some may think I am biased, but to me, I think that the Nigeria Data Protection Act 2023 has had the most impact, the most immediate and pervasive impact on contract drafting. And I'll tell you why. Before that act, the NDPA 2023, most data governance clauses in contracts at best were deemed to be good practice. So, but fast forward a few years, they are no longer just good practice. In any commercial transaction, these clauses are now compliance obligations. And so think about any kind of contract. Again, I may sound biased. Technology contracts, software as a service contract, any fintech looking to plug into some API anywhere, outsourcing agreements, even M&A deals, data processing clauses, and I dare say standalone data processing agreements have become standard. So what that means was in 2015, 2016, 2017, these clauses may just be 2 paragraphs in a 5-page contract. Today, you are looking at the very least at additional 10 more pages because these clauses are no longer good to have. They are now at the heart of commercial transactions. And I will end this by saying, if you take any fintech agreement as an example, right? The main negotiated clauses in this contract are clauses that has to do with third-party vendors. I mean, how do they process their customer data? How do they process BVN link data, phone data, email data, device identifiers? Now, all of these things are key. So just so that I land this, and we'll pick it up from here, I would say the Nigeria Data Protection Act, has not just added clauses to contracts, right? It has changed risk allocation, different from the way we used to know it. So a 5-page service contract can easily become 20 pages just by that one legislation. And that's not to downplay the other legislations. They've been equally impactful, but I think the NDPA stands out. Thank you very much, and back to you, Hilda.
Hi, Diana. Yes. So
Hi,
trade,
Hilda.
yes. So trade in Nigeria, or trade has been moving along national, regional, and international lines. So in considering the African Continental Free Trade Area, which is an economic pact that has brought about a more coordinated way of carrying out intra-country trade, we see the Nigerian businesses are increasingly operating across multiple regulatory and legal systems. So in your view, what is the most significant contract or regulatory risk Nigerian legal teams are underestimating in cross-border deals? And how is that risk changing the way sophisticated transactions are being structured and negotiated?
Thank you so much, Hilda. That's a packed question, but just to align with what Rotimi had said earlier, and not to sound biased at the risk of sounding biased, but I think the Nigerian Data Protection Act did significantly change contracting in recent times. But now to my question, what risk could we be underestimating with? So the world is moving. And there's such an emphasis these days on regional collaboration, regional trade. What is the ROI for us? You would hear it in trillions. They've quantified it in trillions of dollars. And I think that the general consensus amongst us African countries, not to even speak far and wide, is that this thing needs to happen. So what are the enablers? And you see that there are new laws coming up, the digital economy bill, all those things coming up to facilitate these things. So generally, in reality, the world is moving towards, or Africa in particular is moving towards collaboration, trade. How do we move people freely, goods, services? We want to almost operate a borderless continent. So that's what's happening in reality now. In terms of contract drafting, and it's also seeping into how we draft our laws as well. For example, I don't want to belabor the point on the Nigerian on data protection laws, so I wouldn't. But I would say that because of the nature of the interconnectedness of Africa right now, how everywhere is one global village, our laws have started to recognize things like that. For example, the Nigerian Data Protection Act, if you look at it closely, you would see that it says it doesn't limit the law to a region. That law has, by its drafting, has extraterritorial application. And that's what we find across many African laws that deal with data protection. So when you are drafting contracts and when you're even negotiating your deals, you ought to be very careful about what other laws you might be triggering. So it's fine, it's easy and fine for you to say applicable law under your definition section. The laws that apply to this transaction will be the Nigerian laws. It's easy for you to write that. But in reality and in practice, what you are doing, especially with regards to deals that would transcend borders, maybe triggering other people's laws. There may be things you need to take into consideration. There may be things that are allowed here that are not allowed in another country. So that may be something. I wouldn't say that we are underestimating it, because a careful lawyer wouldn't underestimate it. But it's also that even in your best intentions, you may be blindsided by what other laws that you may be triggering by virtue of your cross-border deals. There was a second question. If you can please ask me again, it skips my mind. I think something around the best practice. If you're speaking, you're muted, I think. Okay, you're not muted.
So why do you think the risks continue to be overlooked? So the first question
Okay.
was, yes.
Okay, so I think it's simple. I wouldn't say they are overlooked again, but I would say that is because things are changing rapidly. There are different policies springing up, different revisions to laws happening. And if you don't have, if you're not privileged to be in an organization that has the resources to constantly track these changes, it's easy for you to be blindsided. Then you have a contract that on paper looks good, but in reality would cause drama when it is trying to when we try to implement the terms in the contract. So yeah, I don't think it's been over. It's things are fast paced, so you have to try to be keeping up. You have to keep up and try to be as fast paced as those developments, and that let that reflect in your drafting.
Thank you for that response, Diana. Do you want to add anything?
No, I'm good. I was just reaching to mute.
Okay.
No, good.
Okay.
That was
Fantastic.
perfect response from Dan.
Okay. Thank you again. So over to you now, Rotimi. We are in a world, in a century where we've seen the proliferation of artificial intelligence. They're everywhere. And a concern that we have now observed as touching the adoption of artificial intelligence in African markets is that most tools are trained on legal systems and contract copyright from the US, the UK, Europe, and may not adequately reflect Nigerian statutory framework. How significant is this barrier in practice? That is, if you consider it a barrier, how significant is this in practice? And what would a truly Nigerian-ready artificial intelligence legal tool need to demonstrate?
Great question, Hilda. And this is one area where you have to stop me so I don't keep going. But I'll be true. I'll be true to the question. First of all, yes, the premise is correct that most AI legal tools are trained on US, UK, or EU legal corpus. And honestly, it is a significant barrier to some 98% of lawyers. The remaining 2%, it really doesn't matter, but the 2% are very, very negligible. So I'm speaking to the 98% of lawyers. I would treat this honestly as a serious practical risk. And why is that? A tool can be sophisticated. We know tools that are sophisticated, right? And still misread Nigerian agreements if the assumptions come from another legal or commercial environment. And this might sound like a moot point, but it's not. I call it the danger, is confidence without jurisdictional competence. Lagos state law, Nigerian regulatory practice, Nigerian enforcement realities. Think about Nigerian specific kind of risk, foreign exchange risk as an example, or our infrastructural risk. Think about the typical boilerplate clauses on force majeure, right? If you use an AI contract tool that is trained exclusively on UK or US law, where infrastructure is assumed to be great, right? Like no electricity court. Now, force majeure in those contracts are truly acts of God, like Hurricane Katrina and the likes. But in Nigeria, right, events that really could trigger force majeure are things like infrastructural issues, power grid issues. My point is, an AI tool that analyzes a contract for risk, assuming UK or US factors, may give a green light to a clause that it ideally should flag in Nigerian context. And this is not theoretical. So the second half of the question says, what should a truly Nigerian-ready AI tool demonstrate? And very quickly, I would say them. There are three things at the list. Number one is grounding in Nigerian statutes or Nigerian legislation. We've named the statutes, right? These tools must be grounded in Nigerian law, or at the very least, must have linkages where the tools can be grounded in a source of truth, a Nigerian source of truth. So I've said two things. It's either the tool is natively trained on Nigerian law, or it has the capability to be grounded in Nigerian law. Number two, I've spoken to it already. That tool must be aware of Nigerian commercial realities. And number three, right? I think that a Nigerian ready tool must be intellectually honest. This is what I mean. The tool must have inbuilt verification flags that say, for instance, this analysis applied general common law principles. You, the user, should verify this clause against current Nigerian legislation and recent judicial decisions. If I see those three things, I give it a 90 over 100 straight up. Thank you very much.
Thank you for that response and for restricting yourself. I know that you probably have a lot more to say on the subject matter, but again, thank you for being considerate of the time. But again, a fantastic response nevertheless. Now to you, Diana. What artificial intelligence has done is that it has made legal work faster, easier, and has reduced the turnaround time for work delivery. Your AI tool now could be said to be your assistant, your legal assistant, or even a paralegal. What would you say is the impact of this on legal service delivery in Nigeria today?
Thank you, Hilda. That's an interesting question. Before I answer, and not to make it a habit, but when Rotimi said that in Sena climbs, acts of God are actually acts of God, I thought to myself, so here, what do we have? Is it perhaps maybe acts of man or acts of bad government? I don't really know, but it made me chuckle a bit. Yeah, but to answer the question, the impact of AI on legal services, I don't think, I'm yet to be persuaded that it will be different from how we see AI impacting every other sector, every other profession. I think that the impact is going to be the same. We're going to have, it would, if used cautiously, make us more effective. It will cut turnaround time. It would help you, and if you interact a lot with your AI now, specifically generative AI, your chatbots, the ones that you tell to do tasks and they do it for you. If you interact well enough with it and it is smart enough, it begins to learn you, begins to learn your language, begins to know what type of punctuations you don't choose, what type of words you don't choose. It begins to sound more human. So if you interact with it more, you realize that your prompting and reprompting reduces. You prompt it once, it gives you the output. So cuts turnaround time, makes you more efficient. It's even good as a sounding board. You have an idea, you tell your AI tool, and I know some of us are guilty of it. You tell your AI tool, it looks at the pros, looks at the cons, tells you its own opinion, although it's not human, and then you can then take with that information and do what you want to do with it. So I think it's going to, yes, all those effects is going to cut turnaround time, is going to make the legal services more effective. But I must qualify this statement with the fact that generally AI tools usher new risk. We know them, we've been speaking about them for years now, we've been talking about them. Bias, hallucination, just purely wrong information, outdated information. It can, as Rotimi alluded in his answers, it can be importing things that don't apply in your situation. And it will sound so confident. I don't know if we've interacted with all these generative AI tools. It will give you an answer and it will be confident. And then you correct it and it will say, sorry about that, but this is the right answer. After it has told you, or it will say, you are right to catch that. So if I'd taken that information at face value and ran with it, I would have run into serious problems. So it has known risk. We know of it. You have to cross-check what it gives you. And the caution message that Rotimi alluded to also applies. It should be able to tell you that it has limitations and you have to confirm your answers. But I think all this risk will be reduced organizationally, if you have ownership of the tool and you decide how to responsibly use it, that's one way. But the human in the loop factor is very important. We need to have people who can review these answers. If you are a solo practitioner working in a small firm, working in a big firm, and you rely on those tools, you need to know that you cannot take their responses at face value. I'll give you an interesting situation, real life, that happened in an African country. It's happened that in this country, they had the recurring case of lawyers going to court with fabricated cases. Like, this AI tool would give you very local names, give you very believable facts, but those things never existed. So these people would go and they would drop it and they would plead their case in court. And when they are reviewing everything, they find out that this case actually doesn't exist. It will even give you citation. And in that particular country, they came together and said, no, for lawyers, we need to come up with an AI guideline, an AI policy, so that you could be guided by that. But I said that to say that we know these things. We know the risks that abound. We know that you shouldn't share sensitive information. We know that it could be biased. We know that it can perpetuate the bias of its owners. But we know those things, so we also know how to reduce those risks, how to significantly reduce them. Human in the loop, ownership, not taking anything at face value. Once we balance those two, the advantages and the disadvantages, I'm sure that we can fine-tune it to make sure that it is at optimal performance and it helps us with our efficiency and turnaround times generally. So my one-line answer is that it is going to significantly improve legal services in Nigeria if used cautionary.
Okay. Thank you so much, Diana. So just based on what you've said and your response, so I'll throw this open to yourself and Rotimi. For a solo practitioner who has not had the opportunity to work in a tier 1, tier 2 firm, or hasn't worked in a structured environment, but now wants to rely on artificial intelligence for corporate transactional practice that are quite niche. So say, for example, you now have AI assisting on mergers and acquisitions, you have AI assisting on turnkey agreements. So what would be your word of counsel? Because now the person is a solo practitioner, hasn't had the opportunity to actually gain that relevant experience, but now has access to artificial intelligence that can help in his or her practice. What would be your 2 cents, your word of counsel, very quickly?
For me, I would say that the fact that you are a solo practitioner doesn't mean that you are absolved or that it's excusable that you would go with, for example, to court with a case that doesn't exist. Now, you are trained in school. The AI just came to enhance our lives. You still have that training as a lawyer. You went through your 5 years, 6 years for some. You did your law school. You've gotten your certificate. So you know how to do legal research. You know where to go to find the information that you need for whatever you need it for. You know where you have repositories of templates. You also have a community around you, hopefully. So if it's a field that you are not very comfortable with, you can call 1 or 2 people within your network to kind of give you a foundation. I would discourage AI being your first recourse. Even if it's going to be your first recourse in an area that you're not too comfortable with, make sure that everything it gives you, you fact check it. You can even ask, do you know, for generative AI, you can ask it for its sources and it will give you the hyperlinks. You can even tell it that, give me sources directly from the official bodies, and then you can verify those things. So it does not mean that because you are a solo practitioner, you don't have experience. It doesn't really excuse knows you, you've gone to school, you have the training, you have a network that you can rely on. So I don't see why you should be separated from the obligation that applies to everybody.
I absolutely agree. Thank you so much. Thank you so much. I don't know if Rotimi has anything to add to that.
Just to add, well, just to say that, Diana, well done. Yeah. If I had a one sentence, I would say to lawyers, lose your fear of the sciences. That's all I would say. Lose your fear of STEM, right? Experiment, know the capabilities of these tools, what they can do and what they cannot do. Know their strengths and know their limitations. And that's where you start from. And I dare say that it's an extension of the duty of competence anyway, that you know what tools you can use for your practice. So yeah.
Thank you. Thank you for that. Now, again to you, Rotimi. The MBA SBL conference theme this year is Beyond Reforms, Measuring Policy Impact. In your opinion, what does meaningful measurement actually look like for legal reform in Nigeria? How do we move from announcing change to demonstrating that it has improved the quality, speed, or fairness of commercial law in practice?
Fantastic question again, Hilda. And let me just address this spot on. It will not sound nice, but the truth is Nigeria has become very good at announcing reforms. But the more serious professional task before all of us is to measure what has really changed in commercial life, right? And that is what the SBL June conference is all about. Creating a room where practitioners, regulators, in-house counsel, business leaders can move from just celebrating reform to actually measuring impacts. To the second half of your question, what does it mean to measure impact? I think it's three things, and I'll say them very quickly. The first measurement to me is transaction cost. So the questions are, has it become cheaper and faster to close a deal in Nigeria? Are timelines compressing? Are investors, foreign or local, reporting less friction? That's measurement for me, number one. Number two is access. So all of these reforms, are they reaching SMEs and small businesses? We all know that the small businesses are the heart of any nation. So are these reforms beyond the large corporates? Are they impacting SMEs? And the last one I would say is predictability. And to the lawyers, of course, particularly to those in litigation and even the commercial lawyers, can we today advise a client with confidence about the likely legal outcome of a matter? Now, let me double click on that a bit. Artificial intelligence at its heart, it's a prediction machine, right? It learns from historical data and can predict the future. So what it means is we have all of these tools, but in terms of the laws, the legislation, the reforms that are being peddled today, can we say to our clients, on this matter, this is the likely outcome? So for me, those are the three tests. And to be honest, I may be wrong, but the June conference in Abuja, the 20th annual business law conference, will answer this question. I promise you, there's a reason why it is tagged Beyond Reforms, Measuring Policy Impact, right? It's a deliberate challenge to professionals and policymakers to stop counting laws and legislation, right? But can we begin to start counting outcomes, right? And so that is why everyone on this call, whether you're a practitioner, whether you are a regulator, whether you are an in-house counsel, a business leader, we have to be in the same room. And that room is in Abuja in June. Back to you, Hilda.
Thank you, Rotimi. Thank you so much for that response. We have a question here from Adeni Thompson, and he has asked, how does one cross-check AI information without returning to the traditional methods of research? And I believe Diana has responded to this question, but I don't know if either Rotimi or Diana has anything to add or...
Let me quickly respond. Okay, Diana, please go ahead. Go ahead.
So let me just
after you.
put 2 lines, just because I don't want to lose my train of thought, but also just to piggyback off what you said. I'm particularly excited about the theme for this year's conference because of all the reasons you've mentioned, but also because of the conversations it is likely to start after. The areas that we can see that we can potentially influence within our country. So I'm just excited about, to me, it seems like the domino effect of bringing the smartest people, and I'm biased because I'm a lawyer as well, but like the smartest people in the room to discuss implementation and effect. The domino effect of that is what I am actually super excited about. So it's a place to be. It could give you ideas to even reform things in your own sphere. Whatever. Okay. So moving on to this person's question, my one line, which I had said before, is that you should ask it for its sources. Confirm that it got the sources from the authorized public institution that it's supposed to get the source from. You can ask it to critique its answers, to verify its information, just to fine-tune the answers a bit more and know where you're going to start from if you're going to investigate the accuracy of that information. Rotimi.
Thank you, Diana. And just piggybacking on your response, I will add one more. Now, what I'm adding, remember I mentioned the 2% of lawyers before now, right? But it goes beyond that 2%. Ensure that whatever tool you are using, no matter how great and mighty it is, ensure that by yourself, that same discipline you have learned all your life as a lawyer, ensure that you ground that tool in a source of truth. That's a primary source. I'm not going to name names, but we all know those sources, the law reports, where we go to check. Now, there are ways you can connect whatever tool you are using to a source of truth. So after the tool has given you its first pass, you do a second pass to say, I'm happy you cited all of this case law and all of this legislation. Now, I'm connecting you to this source. This is Nigerian law. Now begin to double check yourself. I promise you, you are going to see 100% reliable output. And everyone on this call can get it done. Len, thank you very much.
Thank you, Rotimi. So in the next 2 minutes, 2 minutes each to Rotimi and to Diana, I have this interesting question for you. In law, we have a number of repetitive tasks that does not necessarily require unique cognitive abilities. Now, for solo practitioners, law firms, in-house legal teams that are watching today, and they're trying to build a strategy for the incorporation of artificial intelligence in their practice, but they are not sure of where to start, what would you consider to be the singular most important first step they should be taking right now? So over to you, Diana, and then Rotimi.
Okay, I get to go first. Okay. So for me, if you are going to decide on AI, the first thing that I think is very important is to decide your stance on it. What do I truly believe about AI? And it also applies organizational wide. It applies to an individual themselves, but it also applies to an organization. An organization can say that our stance on this AI thing is that it is the future. We are grabbing it, we're taking it hook, line, and sinker, we're incorporating it into our workflows. That could be one organization stance. And another organization can say, well, we're approaching it with a bit of caution. right? We want you to use it, but we would select the tools that you would use it on, or you would use the tools you would use for your task. So we're a bit cautionary. Another organization can say, well, no, I mean, we have been doing fine before now, so why should AI potentially disrupt how we're approaching things? So decide your stance on it. Am I open? Am I slightly open, or am I closed? What is your stance? What do you believe? Now, a number of people like me believe that incorporating AI into your everyday task is inevitable. So I'm not going to, a girl like me is not going to say that they're not going to use AI. We would use AI, we have our preferences, but also we would be very careful. We always ensure that there's a human being in the loop, which is me in this instance. So the first thing I would say is decide your approach, and that will just kind of guide you on how you would use it or whether you would use it or not. So decide your approach, decide your stance and your feelings towards AI, and then move on from there.
Thank you, Diana.
Fantastic response, Diana. I mean, the first thing is vision. We can't emphasize it enough. The next thing I would say, and my one thing is experiment, pilot. Hear me and hear me good. There is no expert anywhere on AI today in terms of what it really can do in different industries. Yes, there are those in the labs developing, but in terms of what it can do in particular use cases, I say it without mincing words, there are no experts. Everybody is learning on the go. All I would say to you all is be one of those people who are learning and not one of those people who wait till 2028 and find out that they are a relic of the past. So the first thing is to pilot. Now, let me break it down. Look at your workflow in your firm, in your office, in your solo practice. Is it just choose one thing, just one thing, not plenty things, one thing. Contract risk review. Is that a pain point for you? Or is it due diligence? Are you an M&A lawyer? Choose just one thing that is high volume, right? But low complexity. Then adopt one tool that you are comfortable with. But don't stop there. Now measure. And if you have a team, better. Measure with your team. This tool and this workflow, did we get work done faster? Was it more consistent? Are we happy with the results? Now, of course, without mincing words, when I say experiment, you experiment responsibly. There's a framework I typically teach. I call it the green, amber, red. Green is I can use the tool and subject to verification. Amber is, oh, I need to check with my superiors. Red is no. I mean, I will not use AI in this space. But let your approach be evidence-based. Start small, start narrow, start deliberately, then begin to expand. And as you document your experience, you are also documenting your AI use policy in your firm or in your office. For me, that's the way. And we are not going to wait for some external regulator to come regulate us. We have to do it from the inside out. So you pilot, you experiment. That's my one-liner. Thank you very much.
Thank you, Rotimi. So if you're a solo practitioner, in-house legal, a member of an in-house legal team, from Diana, that the first thing when you are trying to build a strategy for incorporating artificial intelligence in your one of fear. And we've also listened to Rotimi, who said, look for one problem and look for the tool that you're most comfortable with. Experiment and being too complicated. So thank you very much for taking a wonderful conversation. Watching has also learned something valuation. Yes. Thank you, Rotimi. Thank you, Diana. So again, just to remind us, this webinar is brought to us by Optal AI in collaboration with the MBA SBL team. And Optal AI is an AI-powered contract intelligence. I'm about to I was going to emotionally blackmail us by saying it is for Nigeria by Nigerians. Optal does. And what's day-to-day practice as an attorney? The Optal teams for the next 10 minutes. Optal AI team, over to you.
Okay. Yeah. Thank you, everyone. And this was such a very educative, informative session. And I'll introduce myself. My name is Oluwafemi Ogunshola. I am one of the co-founder and CTO for Optel. And today I just will.
Hello, Femi. A
Yeah.
little bit more volume, please.
Okay. Let me know. 1 second. Let me turn this up on my end. Okay, think I should be loud and clear now. Okay. All right, so please just let me know if you can't hear me. I will try to project as loud as possible. Let me share my screen as well, and we can walk through the demo together. All right, so let's get started. So first things first, yep, as mentioned, Opto is a legal AI tool. I'm sure many of us in here are maybe familiar with one or two. There are so many different tools. What makes Opto very special and different is we prioritize, we market ourselves as a legal intelligence platform, which means we really do drill into things like jurisdictional specific, and in this case, we've trained our models and systems to the laws within Nigeria, right? So it allows for you to be able to review your contracts, research, pretty much be aware and know when laws are changing within the jurisdiction you're in. And it's for both, lawyers and law firms and in-house legal counsels, right? And so let me just quickly take you through. So this is what Opto looks like on the platform. Almost like any AI tool, it's something where when you enter, you're able to start by prompting with whatever is on your list of things to do for the day, right? And if it's to drafting contract, it's as simple as entering your prompt into the prompt field here. And so I will take you through what the drafting flow looks like. Sure. Okay. So I'm just going to take this prompt here. So I'm just going to provide a prompt here to just draft the lease agreement. I've provided some details here. So the more details you provide, and as it's been mentioned through some of the answers that's been provided, the AI tool is just there to assist and to help you simplify and make your work easier. So the more you're able to spell out and give details, the better it's able to actually answer and tailor to what give you the right responses, right? So in this case, we try to provide details on certain things within the agreement that needs to be drafted. We do have a jurisdictional um, selector here, which allows for you to be able to select which jurisdiction. For right now, we have trained our systems within the US laws and Nigeria, UK, and Canada. So for this specifically, I will choose the Nigeria as the jurisdiction. And for this also, I've created a playbook within the playbooks here that allows for me to be able to draft or review against a playbook. But I will show this more when I'm going over the review flow. But let's hit draft. So draft in. Right. So depending on the length and the detail of your contract, this, like any other tool, it's a matter of just waiting for it to respond. It's a quick, no more than a minute and a half or so, depending on the length of the contract. Once this is done, there are two options that we provide, right? You can either continue to chat with the AI within the chat box, or you can, open the document that's been drafted in our editor. So we've created something as close as possible to Microsoft Word, given that that's what most users are familiar and comfortable with. We also have a Word add-in that is launching in the next couple of days as well, which allows for you to be able to take this and continue to work with it in your native Word um, application. So once this is drafted, you can pretty much review it in here, or if there are certain things that you may want to ask or verify and clarify, you can always prompt and ask the assistant here to clarify more in here. So if you want to refine section 4.2, it's something where it will pretty much take the prompt in and look into that. It has the context of everything that you're already drafting, and it's able to propose an edit for you for that particular section. If you do prefer that, you can then apply it to the document. So I'm kind of just breezing through some of the key functionalities, so I'm not going in depth. If you do want to try this out, we do have a free trial, and we're going to open up a free trial on the platform for anyone to be able to log in for 7 days to try it out and see if it's something you like before you subscribe to it. Next thing on here, I'll go over the review flow. So in here, you can trigger the review, but I will take a step back to here and start on a fresh document so I can import another agreement and select the jurisdiction. And in this case, I will run this against a playbook. Yep, I'll run this against the playbook. So what this does is we've trained, again, most of the training behind the system here is to be specific to the market standards within the jurisdiction it's in. So upon every review, whether a playbook is included or not, we run it against the market standard in that jurisdiction, right? And if a playbook is included, what happens is we run it against the rules and the clauses that are set within the playbook first. Once we do that, then we open it up more into then it opens more into a general review, just in case your playbook is either outdated or maybe it misses a few things that were recently updated in the jurisdiction you're in. So once the review is done, just because this may take time, I will, oh, wrong page. I will just open one in the interest of time. I will open a document that has already been reviewed. Okay, so once a review is done, what happens is you're into the same into the same editor where we redline the document. If you don't want to see the red linings on there, you can definitely turn those off, but the red linings are added to the document, which you can then accept or reject those red linings. Or if you want to prompt to ask more about that particular suggestion, you can do that. If you also want to go through the findings panel here, this is the exact same things as the redlining. Just, for different people, sometimes you may want to see it on the document, and sometimes you may want to look and read in the detailed sections instead, where you can actually see, okay, in this case, this part where it's redlining is comparing it against the playbook that we selected in there. So there's certain things where if we're referencing the case study or anything that a source that's been added, we reference that so you know where each recommendation, each change is coming from. Along with that, we also provide different options to be able to say, okay, this particular recommendation may not fit what you need. It may be too strict. You may be able to then select different alternatives to the recommendations that the system is proposing. Yeah, and with that being said, that covers the before I forget, the next aspect is with each review that's run, we also generate a summary, a review report, just on a high level. If it's in a case where you kind of just want to review the document and on the go review just a high level overview of what is in the agreement and some warnings or just a result of what the review is. You can have this shared with uh, whoever needs that high level report of that particular agreement. And the next aspect to this will be the share and the export functionalities. So with this also, you can share the agreement, both the review or the contract, or you can either share the review report or the contract or both of them with external parties, or if you have the team's subscription, you can share within within the team and then select what permissions they have. In here, it allows for you to be able to share this with an external party by including their name and email. They get the link in their email. When the link is shared, you can also copy that link and paste it in your browser, and they get a view-only access to the agreement, right? In the near future, we're working on other functionalities to be able to provide more options when sharing the contracts externally. With this, you can also export both the contract and the review report that's
Hello,
generated.
Femi.
Yep.
Sorry to interrupt, but you have 1 more minute.
Yep. Yeah. So yeah, with that, you're able to export both as a doc or as a PDF. With that being said, yeah, sorry, I'm kind of just breezing through this with the limitation in time. But yeah, to get a fuller overview of what the platform does, I would highly recommend that you take the time to just visit uptal.ai. You can if you would like this to be pitched or introduced to your firm, you can book a demo with us, and what we'll do is set up some time with your team and kind of just break it down to you. We also have something called a design partner program, where we pretty much just partner with different firms, different technology groups, and in order to work with your firm and build almost an extension of your IT team, right? You let us know what you need in an AI tool, and we build it on top of the base of what we've built, and we implement it for your firm, right? And if it's something where you would want us to come in and provide knowledge, training, and things for your team in general, it's also something that we offer as a company, right? So yeah, please definitely check it out. Feel free to go on in here and get started on a free trial, and it's 7 days. Test out the platform, and yeah, we'll also be at the conference in June to take any questions or any demos that anyone may want to see as well. So we'll be in Abuja as well to, take questions and answer whatever questions anyone may have. So that is it. I was hoping to have more time for questions, but we'll take that. Maybe again, you can reach out to us through our website for any questions or information that you may need. Thank you very much.
Thank you, Femi, for the demo. Thank you for taking us through how Optal AI works. I hope everyone watching, the audience, has learned a thing or two. Just to reiterate, the Optal AI team has said that they would make available a 7-day free trial should you want to engage with the application. So kindly take that offer up. Our time is fast spent. We have a question here from an anonymous attendee. For a cross-border financing agreement involving parties in Nigeria and South Africa, would it be preferable? So I'm going to answer this question. Would it be preferable to adopt the NDPA, the PIA, or a dual compliance approach for data protection obligations? I'll hand this question over to Rotimi to answer in 45 seconds.
Fantastic question, and I'm putting the answer in the chat there. So my answer is that there is not really a choice. If the financing involves personal data of Nigerian subjects, the NDPA applies. If it involves South African subjects, then POPIA applies. Both laws have extraterritorial reach, of course, based on where the data subject sits, not where the contract is signed. So, but I will say to you very practically, if you are drafting in this case, always map the data flow before you write the data clause. So what that means is you ask yourself, who is the controller, who is the processor, what do the data subjects, and where do they sit? The second thing is where two laws diverge on stringency, always defaults to the higher standard. That gives you compliance with both in one single clause. And the last thing I would say is that address cross-border transfers explicitly in both transactions. So the sum is that for financing transactions of this kind, I would not draft a single law clause. I would always make it a dual law clause. Thank you very much.
Thank you, Rotimi. So from Jacob Ayemere, please can you make your website available here? The website is optal.ai. That is HUBTAL.ai. So again, that answers your question, Rukaya Umar, who is asking us to restate the name of the AI tool. The AI tool is Hubtal.ai, Hubtal.ai. For further questions concerning the subscription or how the subscription works, please reach out to the Hubtal AI team by visiting the website www.hubtal.ai. This brings us to the end of today's session. On behalf of Hubtal and the MBA section on business law, many thanks to our guest speakers, Rotimi and Diana, for a thought-provoking conversation. This is a reminder again that the 20th MBA SBL International Business Law Conference takes place in Abuja just next month. Details and registration information will be shared with all attendees after today's session, along with the recording of this webinar. So if you're interested in the recording of the webinar, you can find the recording of the webinar on the MBA SBL YouTube channel. So just go to the YouTube channel and type at MBA SBL. The recording will be available there. If you're also, again, interested in exploring what Hubtal can do for your firm or legal team, as stated earlier, visit Hubtal.ai. The Hubtal team will be glad to connect with you. Again, Rotimi, Diana, this has been a wonderful webinar session. I've learned quite a number of things. I don't know if you have any closing remarks in 30 seconds. Rotimi, Diana.
Yes, let me give my closing remark. Please pardon me, my camera is turned off at this time because we're at the ending, but it's been a very conversation. Happy to be speaking with Rotimi. So thank you, Rotimi. Thank you, Hilda. Fantastic nutrition, fantastic questions, fantastic topic altogether. I also learned from Hubtal team as well. So it's been an it's well for me.
Thank you, Diana. Rotimi.
I would just re-echo Diana to say thank you everyone for being a fantastic audience and for staying engaged. Thank you to our co-sponsors and all. What I would say to my colleagues here on the call is simple. Don't stop experimenting. Stay curious. Keep learning. Keep innovating. There are no superstars where AI contracts and that intersection between law and technology stands. It's reserved only for those who stay in the game. Thank you very much and have a wonderful rest of the evening.
Thank you, Rotimi. Thank you, Diana. Thank you to the MBA SBL team. Thank you to Hubtal. And thank you, the audience, for sticking with us from the start to the very end. We are happy to have had you, and we hope to see you in Abuja next month. Thank you, and we have come to the end of this webinar. Okay.